or in Cook County, which is where Chicago is. This is because all of these different lawsuits that have prevented the implementation of cash-free bail, the implementation of recently passed gun control laws, and if you remember during the pandemic, many of the restrictions were challenged in these courts. So this is a way for right-wingers to shop for friendly jurisdictions and judges that will help them delay and block progress. And so this bill is basically just a straightforward attack on that, and that's what I like to see. This isn't like a passive thing. You need to be proactive at breaking down their power. And good on it. I like to see this attitude. So another great bill passed. Hopefully the governor signs this one.
That's a reaction to a bill Governor J.B. Pritzker signed earlier this week, limiting where citizens of Illinois can file litigation against state laws or executive actions that they say violates the Illinois Constitution or the U.S. Constitution. And I want to get your thoughts at 217-629-7970. Of course, that's just one perspective somebody shared on TikTok. Known as politically_Illinois. But you have reaction elsewhere, including from State Representative Dan Calkins on the House floor from when this measure passed, saying that it's reminiscent of the tyranny of King George.
The Democrat sponsors of this bill are acting just like King George III. In the Declaration of Independence, the Americans declared that King George was unfit to rule because he was forcing them to be tried overseas by his tame courts for made-up crimes. The Democrats today are doing the very same thing. They pass unconstitutional laws to make law-abiding citizens criminals, and then they make those same citizens travel hundreds of miles to a kangaroo court that they control.
So let's get your calls at 217-629-7970. Which way do you see this? Do you see this as tyranny? Or do you see this as a great step towards progress, as was shared by that TikTok user? 217-629-7970. Let's get those phone calls lit up. Again, 217-629-7970. Good morning. You're on WMAY. Your thoughts?
I see it as tyranny.
Elaborate if you can.
Yeah, I see it as tyranny because, number one, I'm not for gun control. And number two, citizens should have their rights. It should be we the people.
You know, I saw an analysis online saying this would be, detrimental to those who maybe, Mennonites, for instance, say that they feel that they're being unjustly, infringed upon by a state law. And maybe not a Mennonite, maybe an Amish person, right? Or somebody, remove that. Somebody who's elderly and doesn't have a vehicle and they feel that their rights are being trampled on by their government, they can't just walk down the street to their county courtroom and file a lawsuit and challenge the state law or an executive order. They have to instead somehow get to Cook County from Southern Illinois. So this is something that it's controversial. It's now law, effective immediately. Illinoisans can no longer sue in 100 of the counties across the states. They only have 2 of 102 counties that they can sue in, either Cook County or in Sangamon County. So obviously there's a lot of pushback on this. This does not deal with federal courts, so people can still go to federal court and sue wherever, either the Southern District, the Central District, or the Northern District of Illinois. But when it comes to state court, they're not going to be able to file suits in Crawford County, as we saw Thomas Magg file the first lawsuit against the state's gun and magazine ban. They're not going to be able to file a lawsuit against pandemic executive orders that were month after month after month requiring their kids to wear masks or requiring that there be vaccine mandates that you had filed in, say, Effingham County. Instead, any challenges now, according to the law that Governor J.B. Pritzker signed earlier this week, they're going to have to be filed in Sangamon or in Cook counties. 217-629-7970. Good morning. You're on WMAY.
Hi, thanks. What exactly is the reason for the law? What was the purpose? I missed all the actual his reason for doing it.
Yeah, so the debate, and if you missed some of the other reviews of this, we talked about it when it passed the Senate. We talked about it when it passed the House. We talked about it yesterday after the governor signed the bill, or the day before. I can't remember which day this week we talked about it. But review those videos, and you can find that at Bishop On Air YouTube, and you'll be able to watch those. But essentially, they said, listen, the Attorney General's got limited resources, and they can't go out and defend the state against all of these different lawsuits that pop up and various courts, and it's to prevent venue shopping by plaintiffs looking to sue the state. What's interesting here, though, is these lawsuits aren't against the Attorney General. These lawsuits are against a separate constitutional officer, Governor J.B. Pritzker. And while the Attorney General is the attorney for the state of Illinois, he's not the exclusive attorney for Governor J.B. Pritzker, but they're of the same party, so the Attorney General decided to defend the gun ban, for instance. He also was, defending against the COVID-19 mandate challenges as well. So instead of having the governor's chief legal counsel defend these charges, the Attorney General's stepped in. So the Democrats say the Attorney General's got limited resources, and that's why they need to be able to block individuals from being able to sue in various county courts across the state.
So the Attorney General, by law, we don't have enough resources for that Attorney General to cover the entire state? Is that what they're saying?
Essentially, yeah. That seemed to be the argument.
So does that essentially say should we have two Attorney Generals? We should have one for the bottom half, one for the top. You know what I'm saying? I mean,
well, the Attorney General has offices across the state. I think he has an office even down in Carbondale, for instance.
Right. So, I mean, does he ever go there? I mean, I guess my point, I understand why he's doing it from an ideological standpoint. He wants to run for president, and he's got to do all this stuff for national, and this is a test ground. We're second California. I get all that. But what's the actual common sense purpose, practical use? And we have an Attorney General that covers the whole state. How can you say that, well, he can't go down there on Monday, Tuesday, Wednesdays because we don't have the resources in the state of Illinois?
Well, and listen, courts are amenable to scheduling, right? The Attorney General can say, I'm sorry, I'm up in Northern Illinois doing this. The attorney we've assigned to this case isn't available until next week. Can we schedule the hearing for next week? And then all the sides that come together, they're like, yeah, we can go ahead and schedule this when it's most appropriate and convenient for you. But that doesn't apparently matter.
Zoom?
Well,
what about Zoom?
Didn't
we just go through 2 years where everything was online?
That's true. Yeah, and listen, I tuned in to a lot of the Zoom hearings of the COVID mandate challenges, and those were done remotely. So, yeah, maybe that's an option as well.
All right, thanks.
Appreciate the call, 217-629-7970. Getting your thoughts about this bill. Which way do you see it? Do you see it as a great step towards progress, as a TikTok user put online, or do you see it as, State Representative Dan Calkins said, it's reminiscent of the tyranny of King George III? Good morning.
Well, I don't know about King George III, but when did the executive wing decide that the judicial wing can't do their job? I mean, that's why we have circuits. I mean, this goes back to when Lincoln was an attorney. I do not believe in the long run that this will be held to be under our Constitution. So I like the idea. Everything we had to do for, 2.5, almost 3 years with Zoom, and now they want face-to-face meetings, and the reason is we don't have enough money. And that's really the bottom line. We don't have the resources. Resources a dollar. So I really think this is putting the public at a disadvantage, and I think it's against our constitutional rights.
Appreciate the call, 217-629-7970. Good morning. You're on WMAY.
I mean, you really want to talk about taking away freedoms and constitutional liberties. I mean, what better freedom do the people have than to actually file lawsuits at their own county house?
To petition the government for redress of grievances. It's right there in the First Amendment.
Exactly. It's right there in the First Amendment, and that's the one that, the left is all about, save free speech, save the first, and everything like that. And now they're just, rolling over and taking it and letting JB and that political machine do whatever they absolutely want and they're getting away with it. So what I see happening is like the last caller said, the judicial side is going to be like, this is not constitutional, therefore cannot be law.
We'll see what happens, and if this ultimately does get challenged, and whether it's going to be challenged in Effingham County, for instance, and then Effingham County's going to be like, well, we can't do this because it's a new law, so you have to go to Sangamon County here in Springfield, or you have to go up to Cook County to challenge. Or is somebody going to take a challenge to the federal courts to say that this is a violation of the separation of powers, it violates an individual's rights to petition the government for redress of grievances, maybe there's a 14th Amendment, equal protection violation allegation that can be made here, but ultimately it's something that's got people riled up. I've got so much activity on this one story on my Twitter account. It's pretty remarkable. But then you've got others who are saying, hey, no, this is just fine. This is about progress. Again, here's a statement that was provided by a TikTok user, politically_Illinois, talking about how this breaks reactionary power.
Or in Cook County, which is where Chicago is. This is because all of these different lawsuits that have prevented the implementation of cash-free bail, the implementation of recently passed gun control laws, and if you remember during the pandemic, many of the restrictions were challenged in these courts. So this is a way for right-wingers to shop for friendly jurisdictions and judges that will help them delay and block progress. And so this bill is basically just a straightforward attack on that, and that's what I like to see. This isn't like a passive thing. You need to be proactive at breaking down their power. And good on it. I like to see this attitude. So another great bill passed. Hopefully the governor signs this one.
Dan, the governor signed this one. And while he says, this user on TikTok says, it's a way to break the reactionary power. That reactionary power is a check and balance of what people see as government overreach and a fundamental aspect of the citizens being able to hold their government accountable. And again, I go back to the idea of an elderly person who doesn't have a vehicle, lives down the street from their courthouse, wants to go and challenge a state law that they feel is violating their rights. They can't go to their local county court, walk down the street and file a lawsuit. No, they're going to have to find a ride or an expensive attorney to either drive or fly up to Chicago or Springfield in order to handle this litigation. But no longer can they file it in their backyard county court. Now they have to travel to Springfield or Chicago to file these lawsuits. So we'll see what happens with this law, but interesting to see all the activity and the opposition, staggering amount of activity on social media pushing back against this law.